Now let's proceed to Article 234 or Republic Act No. 10396, an act strengthening conciliation mediation as a voluntary mode of dispute settlement for all labor cases, amending for this purpose of Article 228 of Presidential Decree No. 442 as amended, otherwise known as the Labor Code of the Philippines.
Before proceeding for further discussion of the content of this article, I will give first the definition of conciliation and mediation. Conciliation is conceived of as a mild form of intervention by a neutral third party, the conciliator-mediator, relying on his persuasive expertise, who takes active role in assisting parties by trying to keep disputants talking, facilitating other procedural necessities, carrying messages back and forth between the parties, and generally being a good fellow who tries keep things calm and forward-looking in a tense situation. Meaning, conciliation is bringing two opposing sides together to reach a compromise in an attempt to avoid taking a case to trial. It is a process of adjusting and settling disputes in a friendly manner through extrajudicial means. On the other hand, mediation is a mild intervention by a neutral third party, the conciliator-mediator, whereby he starts advising the parties or offering solutions or alternatives to the problems with the end in view of assisting them towards voluntarily reaching their own mutually acceptable settlement of the dispute. Meaning, mediation is a process wherein the parties meet with a mutually selected impartial and neutral person who assists them in the negotiation of their differences. In simple words, conciliation mediation refers to the process of facilitating a settlement of labor and employment issues.
Article 234 or 228 entitled is a mandatory conciliation and endorsement of cases. A. Except as provided in the Title 7A Book 5 of this code, as amended or as may be accepted by the Secretary of Labor and Employment, all issues arising from labor and employment shall subject to mandatory conciliation mediation. The labor arbiter or appropriate dole agency or office that has jurisdiction over the dispute shall entertain only endorsed or referred cases by the duly authorized officer.
Under the said Act, the labor arbiter has jurisdiction to hear and decide claims arising out of the involved disputes of parties, including actual, moral, exemplary, and other forms of damages. Except as otherwise provided under this code, the labor arbiters shall have original and exclusive jurisdiction to hear and decide within 30 calendar days after the submission of the case by the parties for decision without extension, even in the absence of stenographic notes, the following cases involving all workers, whether agricultural or non-agricultural.
Next is paragraph 2 of section 1. Any or both parties involved in the dispute may pre-terminate the conciliation mediation proceedings and request referral or endorsement to the appropriate dole agency or office which has jurisdiction over the dispute, or if both parties so agree, refer the unresolved issues to voluntary arbitration.
In case of failure to reach an agreement within the 30-day mandatory conciliation mediation period, the desk officer shall issue a referral to the appropriate dole agency or office which has jurisdiction over the dispute, or if both parties so agree, refer the unresolved issues to voluntary arbitration. The referral must contain the names and address of the parties, summary of unresolved issues, causes of action, and the relief sought without prejudice to amendments on the complaint by the parties before the office or agency having jurisdiction over the dispute. For voluntary arbitration, the referral should specify the issues to be arbitrated. Voluntary arbitration refers to the mode of settling labor management disputes by which the parties select a competent, trained, and impartial person who shall decide on the merits of the case and whose decision is final, executory, and binding.
Now let's proceed to section 2 of this article entitled Implementing Rules and Regulations. The Secretary of Labor and Employment shall promulgate the necessary rules and regulations to implement the provisions of this act.
Department Order Number 151-16, Implementing Rules and Regulations of Republic Act Number 10396, or an act strengthening conciliation mediation as voluntary mode of dispute settlement for all labor cases. These implementing rules and regulations are SENA IRR pursuant to Republic Act Number 10396, which institutionalized the single entry approach or SENA program of the Department of Labor and Employment or DOLE and its attached agency under Department Order Number 107-10 Series of 2010. Single entry approach or SENA refers to the administrative approach to provide an accessible, speedy, impartial, and inexpensive settlement procedure of all labor and employment issues through a 30 days mandatory conciliation mediation to prevent them from ripening into full-blown disputes or actual labor cases.
Next is section 3 entitled Separability Clause. If any part, section, or provision of this act shall be held unconstitutional or invalid, all other parts or provisions not affected shall thereby continue to remain in full force and effect.
Separability clause allows the rest of an agreement to remain valid even in one or more provisions are unenforceable or illegal. However, some terms may be declared vital to the purpose of an agreement and can therefore not be covered by the separability clause.
Now let's proceed to section 4 of this article entitled Repealing Clause. Presidential Decree Number 442, as amended, otherwise known as the Labor Code of the Philippines, and all the other acts, laws, presidential issuances, rules, and regulations inconsistent herewith and hereby repealed, amended, or modified accordingly.
Any other law, presidential decree or issuance, executive order, letter of instruction, administrative order, proclamation, charter, rule or regulations, and parts thereof contrary to or inconsistent with the provision of this act is hereby repealed, amended, or modified accordingly.
And the last one is section 5 of this article entitled Effectivity Clause. This act shall take effect 15 days after its complete publication in the official gazette or in at least 2 newspapers of national circulation.
An agreement shall become effective on the date of the signing hereof by the parties and shall remain valid and enforceable unless earlier terminated, revised, or revoked upon mutual agreement of parties in accordance with the terms and conditions of this agreement.